Good afternoon. My name is Alena Shautsova. I am an immigration attorney from Brooklyn, New York. In today's Legally Speaking seminar, I would like to tell you about cancellation of removal for permanent residents. That's right, there are two types of cancellation of removal. One is for non-permanent residents, where you need to show that you resided in the United States for 10 years, you are a person of good moral character, you have a qualifying relative who will experience extreme hardship in case of your removal, and you were not convicted of certain crimes. And there is a cancellation of removal for permanent residents, where you need to show, number one, that you were a permanent resident, you have been a permanent resident for 5 years, that you have continuously resided in the United States for 7 years after being admitted in lawful status, and that you were not convicted of an aggravated felony. For permanent residents, it's not necessary to show extreme hardship, believe it or not. So it seems like it will be easier for them, but in practice it's not so easy. And here is why. The 7-year requirement sometimes is hard to meet because the 7-year clock can be stopped, and can be stopped not because you moved out of the United States, but because, number one, you were served with a notice to appear, and service can be done by mail. Sometimes the person is not even aware that the service was done, and with the 7-year clock the 7-year clock also stops when the person commits certain crimes. It's not every crime that will count, but some crimes, and usually the list of those crimes that will stop the clock is longer than the crimes that will not stop the clock, because the only way pretty much for the person not to have the effect of the stopped clock when the crime is committed, if your crime qualifies as a petty offense exception. In all other instances, the clock will be stopped, and the majority views that the clock will not be restarted. So, for example, if somebody came to the United States in 2000 and in 2002 committed a crime that stops the clock, and then resided in the United States for the next 10 years before the person was put in removal proceedings, the person will not be able to qualify for the cancellation because his or her clock stopped in 2002 when they committed a crime. Third requirement, aggravated felony. Aggravated felony is an interesting thing. Different crimes can qualify for it, and a very thorough analysis is needed in every particular case, because, for example, in some states a conviction for shoplifting will not and cannot be an aggravated felony, but in others it can be. It's pretty amazing. The law provides for a list of crimes that would qualify as an aggravated felony, but it's also not often clear which crime would actually, which conviction, which statute would fall under the description. Just recently, there was a U.S. Supreme Court case that held that a crime of violence, one of the aggravated felonies, a crime of violence definition is unconstitutionally vague, meaning that many permanent residents who before would have been disqualified from cancellation of removal because they committed a crime of violence offense which made them committing an aggravated felony, no longer will fall under this bar and will be able to move forward. So it's very tricky sometimes, and lawyers really need to do a good job to argue different points about whether the clock was stopped or whether the person was in fact found guilty in aggravated felony, not just a regular crime. Very often, for example, people with drug-related offenses would file for cancellation of removal. It's pretty much the only option because drug-related offenses cannot be waived by any waiver unless it's 30 grams of possession of certain drug for your own use. So the person would file for cancellation when they're found to be in possession of certain controlled substances. And sometimes when the possession is a big possession, the government will argue that they were also had intent to distribute it, and they're traffickers in drugs and things like that. They were trying to make that conviction an aggravated felony and disqualify a person from cancellation or removal. So cancellation of removal for permanent residence, in my view, is even more difficult to get sometimes than for non-permanent residents. Even after you meet all the three simple looking requirements, then there is a discretion portion of the cancellation, meaning that then the court, the immigration judge, should determine whether or not you deserve to be forgiven. And here we again show extreme hardship, even though it's not a requirement, but very often practitioners will use extreme hardship like standard to show that the various factors play into applicant's favor, and his or her application should be granted. You can read more about cancellation and removal on my website, www.shautsova.com. I also have articles there addressing various points like stop time rule and good moral character, and necessary residence requirement, because it also can be tricky for certain types of green card holders. Thank you very much, and I hope this video was helpful.